attorney at the firm of Vishnik, McGovern, Malaysia. I'm one of the partners of the trust estates and the elder law departments. We have a full service firm, which involves a lot of different departments. We have a real estate department, matrimonial, employment law, personal injury, and essentially we can help our clients with a lot of the different things that they may need on a day-to-day. So thank you so much for having us. We're happy to be joining this, and we're glad to see that there's several people who are interested in what we have to say today. So I'm going to try to speak generally about a lot of different things, and then we can have some questions for the end. We always love to host these because we think there's a lot of information that needs to be given out to the community. I think a lot of people think that estate planning or Medicaid planning is for a specific type of person or individual. In fact, estate planning should really be done by everybody. Once you're an adult, you should have an estate plan. There are several documents that you should have. And so I always say at an absolute base, you should have 4 legal documents. The first one is the most important document, and it's called a power of attorney. The power of attorney is the document that states who would make your financial decisions and who would assist you. They can help you now, or they can help you in the future only if you became incapacitated, or they can help you at all times. The power of attorney that comes into effect right away is called a durable power of attorney. It allows somebody to stand in your shoes to help you make financial decisions, whether it be contacting your insurance carrier, dealing with your bank, if you have tenants, dealing with your tenants at your home, making phone calls for you, just basically being your representative. And the durable power of attorney is in effect the minute you sign it. As long as you and your agent have signed it, they're in effect. Now, the springing power of attorney is the second type of power of attorney, and that document only comes into effect when you don't have capacity to make decisions for yourself. So the durable power of attorney, I'm sorry, it seems there's some, can everybody hear me? Is that okay? Okay, I just got a request to speak louder, so I'll try to speak louder. The springing power of attorney will only come into effect when a physician advises that you're not capable of handling your finances. And so a springing power of attorney can be used by individuals who prefer not to have something that's durable, that goes into effect right away. Now, for either type of power of attorney, if you're capable of making your own decisions and you decide that you want to be in charge of making a certain decision, then in that type of situation, your agent doesn't have the right to take over your decision making. As long as you're capable and you're fine, you're still in charge. So it's important to keep that in mind with the power of attorney. The most other important thing to note with a power of attorney is you have to make sure that you put the right people in charge. It's got to be somebody that you trust, someone that you know is going to make the best decision on your behalf, and someone who you know is going to be savvy, right? They're going to make a good decision regarding your finances. They're going to make similar decisions to you regarding your care, where you should be living, you know, who should be taking care of you and things like that, because that's what a power of attorney does. So it's very important that when you prepare this document, you keep all of those things in mind. That one is the first document. The second document is called a health care proxy. The healthcare proxy is the document which states who's going to be making your medical decisions if you could not make them yourself. So if you are not capable of communicating your medical needs, your medical decisions, if you weren't able to advocate for yourself in a hospital setting with a doctor at a facility, this is the individual who would stand in your shoes to make all your medical decisions, to accept certain types of treatment or to reject certain types of treatment. That would be your agent under your healthcare proxy. Now, your healthcare proxy, you have to name your agents successively. First, then second, then third, and if you want to keep going, you can keep going as far down as you want. But your agents have to be successively, because doctors, medical professionals, they don't want to speak to 2 or 3 different people. They don't want to have fights between 2 or 3 different people. So there should really be a successive order of these individuals. The third document is called a living will. The living will states what your end of life decisions are. It says, in the event that you are suffering from an incurable or irreversible medical or physical state with no reasonable expectation of recovery, you authorize the person under document 2, your healthcare agent, to make decisions to withhold or to withdraw artificial means of hydration and nutrition. Now, that could also mean that if you were at the end of your life, say you were suffering from an illness, let's take dementia or Alzheimer's for an example. In an illness like that, you tend to reach the end, right? Where you can't be given any other kind of treatment or medication to be brought back to your baseline. So in that type of a scenario, you're saying, if I get to that point, don't prolong the dying process. Don't give me machines, don't give me vents and pegs. Don't even give me don't give me water or food, right? If you're already at the end stages of your life. Now, this document should not be confused with a DNR or a DNI. A DNI is a do not intubate. A DNR is a do not resuscitate, or even a MOLST form. A MOLST form is a very specific document which gives very specific instructions to your agent to be able to advocate for you, and to be able to state whether or not you should get, antibiotics, or whether you should get resuscitated and things like that. Those documents are typically signed, a DNR, a DNI, and a MOLST form are typically signed when someone is very ill or very elderly, right? If they decide they don't want to be resuscitated, if they decide that they don't want to be kept alive by artificial means, typically we'd have them sign this document. And I usually recommend we put it on the refrigerator. So if the EMS comes in, or if something else happens and they have to be rushed to a hospital, or they refuse to be taken to a hospital, I want to have that on the refrigerator so that the people who come in to render first aid don't put that patient through what they don't want to experience. But doctors and medical professionals usually don't give these documents out until somebody is really toward the end of their life, or at the point where medication may not be able to help them. So the living will is just a very broad document that if I'm at that point, then I would want you to not give me all this treatment. So it's very important not to confuse the two. I've signed a living will, but I've also given instruction to my healthcare proxy that they better do everything they possibly could to fix me. I gave my husband that warning. I said, you better do everything you can to fix me. And if you don't, I'm coming back for you. So that was my little warning to him. But from my perspective, if I was ever in that type of end of life scenario, I wouldn't want my life to be prolonged if there was nothing they could do to fix me. And he knows that that means like you better talk to 5 or 6 or 10 or 15 different doctors to get that all straightened out. So those 3 documents, power of attorney, a healthcare proxy, and a living will, are all in effect while you are alive. So they are there to assist your loved ones to take care of you. And the important part of these documents is that you're the one choosing who you want in these documents, right? You're the one picking who should be helping you with your finances, who should be making your medical decisions. That's why estate planning is so important, because it lets you make those decisions, even though you may not be at the point where you can make them yourself. So it says, when I'm not able to do things, or if I need help, these are the people that I trust to make these decisions for me. And that to me is the most important part of estate planning, because it allows you to be in the driver's seat even when you can't be driving. So it allows you to advocate and state who you would want to make these decisions. If you don't have these documents, the power of attorney, the healthcare proxy, the living will, what would end up happening is that if there's nobody to take control over your accounts, no joint owners on your accounts, if no one is authorized to make decisions for your finances or to sign on your behalf, your loved ones would have to seek a guardianship from the court, from the Supreme Court under the mental hygiene law. I can talk badly about guardianships all day because I am about this deep in them. I'm a guardian for several different people, and I assist people on a day-to-day making decisions about where they should live, where their money should go, how it should be spent. And I always tell people, let's avoid guardianship because it's costly, it's time consuming, and it takes up a lot of energy for a loved one to have to go through a guardianship process. So as long as you have your power of attorney, your healthcare proxy, that typically avoids having to go to guardianship court, because it tells the court, if I'm not able to make these decisions, this is who I want to do it for me. I don't need to go to court to have a guardian appointed to make those decisions for me. So it's important that those 3 documents are in place to ensure that you choose who you want to be responsible to take care and to assist you with your needs. The 4th document that I had mentioned is the last will and testament. The last will and testament only comes into effect at your death. It does nothing for you during life. And that's usually, the first line that people have when they come to meet with me is like, Constantina, I need a will. I'm like, sure, you need a will, but you need first a healthcare proxy, a living will, and a power of attorney, because those are during life. A will is only going to help afterwards, and you're not going to be here to see it. So the will is important, though, because it does direct who inherits your assets after your passing. And so upon your death, it says, these are the individuals who are my beneficiaries. I leave everything that I have to my spouse, or I leave everything that I have to my children, or I leave everything that I have to the neighbor because I have very crummy children and I don't want them to get anything, right? So the will directs who's going to inherit those assets. The will also states who's going to give out these assets. It nominates someone called an executor. It nominates a trustee if you want to include a trust in your will. Like me, I have a trust in my will because I have 2 little kids, right? I have a 6 and a 3-year-old, now 6. She just turned 6 last week, and a 3-year-old. And so if I died and my husband died, I would want to make sure that when my kids inherit their assets, they don't inherit it at 18, because God knows what an 18-year-old would do with some money, right? And so in my will, it says I give everything that I have to my husband. My husband, in his will, says he gives everything he has to me. Something happens to both of us, everything passes to our children. And so don't laugh. We said that until our children turn the age of 35, we are going to have a trustee be responsible for our children's funds. So we've nominated my sister, who is going to be in control of their money. She's going to set up 2 separate accounts, one for Stella, one for Olivia, and she's going to separate the assets, half for one daughter, half for the other. She's going to have 2 separate trust accounts. She'll use Stella's money for Stella. She'll use Olivia's for Olivia. And they'll use money for health, education, maintenance, and support. I recommend that this trust is in everybody's will, whoever has minor children, whoever has grandchildren or may have grandchildren in the future. This trust should be set up in your will because you want to make sure that that child has what they need and that you've put someone responsible to care for this money. And so they'll use Stella's funds for her, pay out for whatever it is that they need. Say there's $100,000 left by the time she reaches the age of 30. I've directed in that trust that she's going to get a check for 1/2 of whatever's in that trust. So if there's $100,000 left when she's 30 years old, she'll be handed a check for $50,000 because I hope by 30 she'll know what she's doing. And then at 35, if there's any money left, she'll get the rest. And so those trusts are established for their own protection. And because their mom is a little bit type A and wants to make sure that they don't get their hands on it too young and they don't blow through it. So that trust, again, is going to be there to make sure they have everything that they need and they don't just go through all their money. So you can choose whatever age you think is appropriate for your children, for your grandchildren. You may want to consult with your children if it's for your grandchildren, because I tend to see that a lot of grandparents think that like 18 is a good age or 21 is a good age. Unfortunately, 18 and 21 is not what it was when even I was 18 and 21. I just had a conversation with parents of 25-year-olds yesterday, and they said our kids are like 16 when it comes to finances. They don't know a thing about finances. They call us about everything, and they're 25. So I see parents are a lot more reluctant to put a younger age, whereas grandparents are, yeah, sure, they can. So make sure you speak to your kids to make sure you figure out what the appropriate age is for them. And who knows, right? My kids may be very responsible by 18, maybe very responsible by 21. As they get older, right now I don't know because they're only 6 and 3, although I have an inkling of, I have a thought of who's going to be more responsible than the other. But you know, there is a scenario where I'm probably going to redo these documents and revisit this. If I see that the girls are good at handling their finances, I may decrease the age. In your will, you may also want to add a trust for a minor. For a disabled beneficiary. So if you have any beneficiaries who are disabled, or maybe you're concerned they may become disabled in the future, right? And they may need government benefits, whether it be Social Security, whether it be Medicaid, right? All of that needs to be taken into account and determined and discussed with your attorney so that your attorney can understand, you know, where do we have some concerns and where do we need to protect certain types of beneficiaries. Other beneficiaries may have addiction problems, right? They may have gambling issues. They may have other issues that you want to protect them from themselves, other than being a minor. So it's important that all of those factors are discussed with your attorney so that they can make sure that they include the appropriate wording, the appropriate trust, whatever else is needed in their documents, in your will. And then, as I mentioned, you're going to nominate the trustee. That's the person who's going to manage any of these trusts. We also may want to add estate tax planning within your wills. Instead of just doing a simple will, you may need something more complicated, depending on what the value of your estates are. You know, I think people are very reluctant to discuss numbers. I don't know if the feeling is, oh, if my attorney sees I have a lot of money, they'll charge me a lot of money. I can assure you that doesn't happen, at least not here in this firm. But it's important that we know what your assets are. And that's actually what I do is before I meet with a client, I send them a questionnaire that I want them to complete. And it's very important for me to have that questionnaire completed at the first meeting, because then I could direct and I can give instructions and I could say, you know, all right, based on the value of your assets, you need to do certain types of wills. You should have renunciation clauses within your wills. You should have credit shelter trusts within your wills. The estate tax right now is kind of in flux. The New York State is pretty set. It's at 5.94 million. So each person can die with that amount in their names and there won't be any tax. Now, when it comes to, let's say we give everything from one spouse to the other spouse, the surviving spouse in New York will still only have 5.94 million to give away. So it's very important to consider if spouse A gives everything they have to spouse B, even though spouse A may not have a taxable estate, when they give what they have to spouse B, will that create a taxable estate for spouse B? And so these are the things that we have to look at when preparing a will. I'm always very, very concerned about, you know, people doing wills by themselves, especially going on to online sites. Like I always get these advertisements on LegalZoom or prepareawill.com or whatever. A will is not a form. It should not ever be a form. It shouldn't be a document that you just type something in and walk away with. It needs to be something that's formatted based on your circumstances. It needs to be something that incorporates all the different factors and all the different concerns that you may have in it. Sometimes a will should be done a little bit more complex, and that's why all of these things have to be discussed in order to determine the complexity of your estate plan. So those were the 4 basic documents that constitute an estate plan. Okay, power of attorney as just a synopsis, power of attorney, healthcare proxy, living will, which are all 3 in effect while you're alive. And the 4th was the last will and testament, which only comes into play upon your death. Now, there are people that want to go a step further into planning, right? And that typically happens when people are getting older, right? Approaching retirement, past retirement, maybe 20 years past retirement. It all deals with your comfort and what it is that you're trying to achieve in your estate plan. And it has to be fully discussed and fully understood in order for you to do something like this. People typically come to me, especially lately, to be concerned about long-term care costs, right? What does long-term care mean? Long-term care could mean needing a home health aide to assist you with your activities of daily living, or needing nursing home care right? Because somebody maybe cannot return back into the house. These are two kinds of long-term care. Now, for those who've purchased long-term care insurance, it's great because long-term care insurance can give you money every single day or every single month to cover your care. Some long-term care policies, if you got them long enough, can last for the duration of your lifetime. Those are few and far in between at this point. Other policies last during a specific amount of time, right? So they may be 3 years, they may be 5 years. It depends on what type of policy you purchased. But the policies definitely help defray some of the costs. Now, for those people who never purchased long-term care insurance, they have two options. They can either pay privately, or they can arrange their assets or protect their assets so that one day they can qualify for the federal government program of Medicaid. Now, those above the age of 65 have Medicare, not to be confused with Medicaid, right? So Medicare is insurance, health insurance. That's all it is. It's not long-term care insurance. It only covers doctors, hospitals, sometimes prescriptions, right? Depending on whether you have A, B, C, D, whatever part you purchased. Medicare will also cover short-term rehab. So if I trip and let's say I'm 67 years old, I tripped, I fell, I hurt my hip, I had to go to the hospital. The hospital will be covered by Medicare for the first 80%. The remaining 20% will be my copay unless I've purchased the supplemental insurance. So if I've gotten the supplemental insurance, then 100% of my care will be covered, or maybe there's a little bit of a copay from the supplemental depending on what the agreement is. And so Medicare will cover my cost to be in the hospital. And when I leave the hospital, if I go into a rehab center, it'll cover up to 100 days of rehab. Now, this 100 days of rehab may not be a full 100 days of rehab. So it's important to note this. The first 20 days are paid in full by Medicare. The remaining 80 days, there's a copay of about $180 or so a day. If you have a supplemental insurance, they may pick up that $180. I don't know if they'll pick up all of it. Some of it, it'll depend on your policy, right? But it'll be up to those 100 days. Now, even though they say 100 days, they don't really guarantee 100 days. It'll all depend on how you're doing in rehab, right? Are you showing signs of improvement and getting better? Are you showing them that the rehab that they're giving you, the PT, the OT, the speech, whatever it is that they're providing you, is actually helping you improve? And are you steadily improving? Or are you refusing to do any therapy? Or are you plateauing and staying the same? If any of that happens, let's say you're plateauing and staying the same, or you're refusing rehab services, or you've gotten to the point where you've increased, and now you're staying the same, which is again the plateauing, you haven't shown improvement, then they will cut your Medicare days. Regardless of how far along you are in that 100-day period, they will stop them. And they're going to tell you in 48 hours, you have to make a decision. Either you go home or you go to another floor in our facility where you're going to stay for long-term care. At that point, the individual has two options, either go home or facility, right? If they still need the care and they want to go home, but they need a home health aide, or if they still need the care and they want to stay in the long-term care wing of the facility, in the nursing home part of the facility, they can either pay privately or they can apply for government-based assistance from Medicaid. Okay, so Medicaid, again, is different from Medicare. Medicaid aids those who don't have assets. You need to be under a certain threshold to apply for Medicaid. They look at your income and they look at your assets. For either type of Medicaid, whether you apply for Medicaid at home or you apply for Medicaid in a facility, they're going to look at your income and your assets, and the income and assets of your spouse also. So it's important that your affairs are in order if that time comes and you're going to want to be applying for Medicaid. To apply for Medicaid, you have to have less than $15,900 in assets. And your income is supposed to meet the threshold of $884 per month. I know those numbers sound impossible, but they are definitely at a limit where we can get you if needed. And we'll talk about how we can do that. Now, the tricky part is that if you wanted to stay in a facility, Medicaid in the facility has a 5-year look back, 5 years, which means that if you apply on June 1st, 2021, they're going to look back from June 1st, 2021, all the way back to June 1st, 2016 to see what you've done with your money. You're going to have to give them bank statements for every single month for every single account that you've had in that 5-year period. You'll have to explain to them if you sold your house, what you did with the proceeds. Every deposit and withdrawal, $2,000 or higher, will need to be explained. It'll need to be walked through. It'll need to be shown to them if it was transferred from one account to another account. If it was an IRA distribution that went into your checking account, you'll have to draw the lines and make the map for them to show them that you haven't actually transferred your assets or gifted away your assets. If you've spent your money, it's okay. That's okay, as long as you have the proof to show that you've spent your money. But if you've gifted your money to family members, gifts to birthdays, holidays, weddings, whatever it was, you helped your child buy a house, you gave away a significant amount of assets, you will not be allowed to get Medicaid until you pay back what you've given. So if in that 5-year time frame, we've calculated, what we do is we keep a list of all the transactions, $2,000 or higher. If we calculate that you've given away $40,000 and it's unexplained, we can't find the receipt, when you gave a contractor $30,000 to fix a bathroom, or you've given your child all this money as a gift, those gifts or those uncompensated transfers are going to count against you and impose a penalty upon you. So it's essentially dollar for dollar. You've given away $40,000, you're going to have to now pay $40,000 before Medicaid will pick up your care. And so that's how the look back works. I'm oversimplifying it. It is a little bit more complicated, but I'm trying to make it English so that it's understandable. But that's essentially it. That's what a 5-year look back is. Now, if let's say you can't make that 5-year look back because you created a trust and you put your house in trust 4 years ago. So you're almost at the 5-year mark. So you're going to go home instead to apply for home care Medicaid. Let's say it's actually called community Medicaid. So if you decide you're going to go home instead, you're not going to stay in the facility. You want to go home, you're going to apply for the community Medicaid. As of today, there is no look back for community Medicaid. I've been putting in applications, submitting the last 3 months of statements, and getting people onto Medicaid quite easily recently. However, that's going to change. The law actually changed last April when we were told by the budget, when the New York State budget passed, and the budget stated that they're going to start implementing a 2.5-year look back on these types of matters, on anybody who applies for community Medicaid. It was supposed to start in October, then it was supposed to start in January, and now it was supposed to start April last month. And we still don't know when it's going to start because the federal health, the public federal emergency that's in place with COVID is barring New York State and not allowing New York State from doing this and implementing this new rule, because it's going to keep a lot of people from being able to get the care. And so this 30-month look back, we're anticipating it to start at some point soon. We just don't know the exact date when it's going to happen yet. There hasn't been any written directive. There hasn't been any written instruction from the Department of Health. There's been a lot of phone calls, a lot of Zoom conferences between the Department of Health, the New York State Bar Association, Elder Law Committee, and all these other agencies, and they've said that they're anticipating the end of this year, but we don't know when it's going to be. So it's very troubling. It's very concerning. We're telling people who are applying for Medicaid that they should, who want to apply for Medicaid or who think their parents may be, losing their ability to do things, to apply sooner rather than later, because we just don't know when that 30-month look back is going to be implemented. And when it is implemented, it's going to be similar to that 5-year look back, where they're going to ask you for 30 months of bank statements. They're going to ask you for any transactions and any money that you're spending $2,000 or higher. That's how we're interpreting it to come out at this point. So essentially, that's what we're anticipating to come down the pipe very soon. And so if you wanted to get the Medicaid at home and from the community Medicaid, you have to have activities, 3 activities of daily living that you can't do by yourself. Feeding, bathing, toileting, transferring, getting dressed. Those are activities of daily living that you can't do. You have to satisfy those activities so that you can get the care. And then you also have to satisfy the financial, like we said, from a financial standpoint, you have to have less than $15,000 in assets. You're supposed to be making less than $884 in income. Although that can be adjusted. If you are trying to apply for Medicaid at home, there are ways that we could protect your income above the 884 limit. So what people tend to do is, while they're still healthy and while they're still well, they tend to engage in planning to get their assets in order, to get their estate in order, so that if the time came, they'd be ready to apply for Medicaid. What does that mean? I'll give you the typical scenario. Let's say someone has a house and they come to me and they have one house, they have $100,000 in the bank, it's a couple, right? The typical recommendation would be, let's put your house in a trust and keep your cash on the outside, and we'll deal with the cash when the time comes. But what is a trust? So I always explain a trust kind of like a box, right? Think of it as a box. You put your assets in this box, you close it, you lock it up. When you lock up that trust, you now have to give the key away to someone that you trust. It cannot be the trustee. You have to give the key away. And so when you make that other individual the trustee, they are now responsible for the assets that are in this trust. The whole point of this trust is that you've given this asset away. You've put it in here with the inability to take it back, with the inability to access it for yourself, okay? So if you put your house in there, the trust says, as long as you're alive, the house is yours. You live in it. If there are rents collected, you continue to collect the rents. You pay the expenses of the household. You still get your STAR exemption, your enhanced STAR, your senior STAR, your veterans exemption for the property taxes, and no one can kick you out of this house until your death. So the trust is protecting the house for you, but it is removing it from your name and putting it in the ownership of this entity, this trust. And so the important thing to note here, again, is that it's irrevocable. We can't undo it. So when you've done it, you've done it. You got to make sure you understand you've given away control over this asset. Now, if the house were to get sold, it can get sold while it's in the trust. But if the house were to get sold, your trustee also has to be okay with selling it. So you would tell your trustee, I'd like for you to sell it. And they can sell the house for you, and they can downsize and get you a different house or an apartment that you can continue to live in and get those benefits that I had mentioned a few minutes ago. And so the trust will protect your residence, and that's the goal of it. So a lot of people tend to put their residences in there. When I wouldn't put the residence in there is if someone tells me, I plan to sell it in the next year and I want to use the cash. So if a client comes to me and says, I'm going to want to sell my house in the next year and use my cash to live on, because I'm going to make a significant amount of money and I don't have any savings, so I'd like to live on the house proceeds. In that type of a scenario, I would not recommend that you put the house into the trust. And the reason for that is because once you put it in there, like I said, you've given up control over it. It can no longer be used for you. So if you've put cash in there, or if you've converted your house into cash, that cash is not supposed to be accessed by you. It cannot be used for your care. It cannot be used for you. It is an irrevocable trust that you've given away and you no longer have access to. So in the typical scenario, husband, wife, 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 husband, husband, whoever's going to come to us and say, you know, my spouse and I would like to put our house in a trust. We'd like to engage in Medicaid planning to protect our house. That's what we would recommend. There are other options, but they don't protect the house fully. So I don't typically recommend them. And now if this couple comes to me and they say, we want to put our house away, that's fine. We do a deed, we do a trust, we can transfer the house into the trust. Once the 5-year look back passes, the house will be protected from institutional Medicaid. Once 2.5 years passes, the house will be protected from community Medicaid, and you'll be eligible to apply at that time. So it's important to note that the trusts don't avoid the look back periods. You're still subject to those look back periods. And so that's something you have to keep in mind, that if you're going to engage in this planning, it has to be done while you're still capable, right? While you're still healthy. And so with that $100,000, the couple may say, well, I want to put my money into the trust also. But I think a lot of people who don't yet understand the concept of the trust say they want to do that. But when I explain to them, once you put that money in there, you're not going to be able to take it out for your benefit, then it's a different story, right? People prefer to hold on to their money. And I don't blame them. My gut would tell them, hold on to your $100,000 because you never know when you're going to need it. You never know what you're going to use it for. If they want to put a portion of it, that's fine. It's up to them. It's got to be, and that's the thing about Medicaid planning. The plan has to be formatted to those specific needs of those individuals. I met with a client 2 days ago, and when I explained this to them, they said, oh no, we're not ready yet for something like this. They're only 66 and 68. They're like, we're not ready for something like this. We don't want to give up control of our assets. And that's essentially what Medicaid planning is. But the tough part is, if you keep those assets, keeping the asset will subject it to claims later, right? So you have to find that balance where you're comfortable enough to give up control of some of it if you want to engage in this kind of planning. Or if you don't, then you don't. Just leave it the way that it is and deal with it when it comes, right? You may have to reverse mortgage the house. You may have to sell the house. Whatever the case might be, you're going to do it when the time comes. You know, there's a huge array of where people stand on this. I always joke about this. My in-laws stand on one side, my parents stand on the other side. My in-laws say, whatever's left at the end of the day will be yours. If there's nothing left, and to my son, not to my husband, not to me, obviously, whatever's left at the end of the day, you'll have it, but we plan to spend it all, right? And my parents are on the total opposite end, that they're like, oh, everything's for you. We're going to save everything. We're not going to spend a penny, which is up to them, but I'm not really on that side either. I'm somewhere in between, right? So each person has to choose what they're the most comfortable with, because this planning is not a one size fits all. Now, if there is one thing to keep in mind is that the asset that you put into the trust is considered principal, right? It is the asset. The principal of the trust will consist of the asset that you have funded it with. There's another part of the trust, which is considered income, right? So if you have a multifamily residence and you put that residence into the trust, the principal of the trust is that house, that property. The income generated from it is the rent, right? The principal of putting $100,000 into the trust, $100,000 would be the principal. The dividends and interest coming out of it would be the income. So there is a differentiation between the principal and income. You as the grantor, the person who created the trust, cannot access principal. However, you can get income. And so the income that's generated out of the trust can be yours. As long as we set the trust up to say it's an income-only trust, it is payable to the grantor, you can continue to receive the income. It's actually a big part of my practice. A lot of my clients are Greek, like me. And their retirement is essentially their home. They live in Astoria, where I live. They rely on their rental income to survive because maybe their social security check isn't that high, or maybe they don't have a pension, right? And so that rental income is what they live on. And so they're very reluctant to give it up, and I don't blame them. I wouldn't either. So we put the house into the trust and we ensure that the income can still be provided to them. That's important to know the differentiation. So that is essentially the way that we would protect assets. Putting the house into the trust is the best way to protect it from potential claims in the future. Now, there are ways that people who still own a home can qualify for Medicaid. And if you have a house and you've ever applied for Medicaid, they're not going to deny you. But the catch is that upon your death, if that house was still in your name when you died, they're going to put a lien against that house to recover any money that they've spent on your care. So it's important that you don't just go off and apply for Medicaid without getting instructions, without getting advice from counsel. And it really should be an elder law attorney. I can't stress that enough. I have a lot of people who I've met later on after they've done their planning initially with an attorney who was a personal injury attorney who did wills, or who was a general practitioner who did estate planning, right? But didn't really know about elder law and gave advice like, yeah, transfer your house to your kid, which is the worst advice I could ever hear somebody give. Give your house to your kid, or yeah, just transfer it, do this, do that. And they don't take into account a lot of the potential downfalls of that. And typically when someone comes into me, they're going to say to me, just like they say, I need a will, right? They'll say, I want to transfer my house to my kids. And that is not the right way to go. You don't just transfer your house to your kids. And I could tell you 4 reasons why, right? The first one is transfer your house to your kids today, you'll be out on the street by tonight, okay? It's their house now. They have the right to decide who lives there, who doesn't live there. Or if they pass away and the house is now owned by your child and not in a trust, but by your child, who's going to get that house when your child dies? Is it their spouse that you don't like? Is it their children, right? So it's important to keep that in mind. That's number one. Number 2 is you'll lose your tax exemptions if your house is transferred to your child, right? Because you may be over 65, you may be a veteran, you may be a senior and have low income, but they're not. So they'll have to pay the higher tax. 3 is because you'll lose your income. Let's say you are getting income, rental income from this house that you're living on. You will lose that income because now it belongs to your child. And 4, capital gains taxes. Now I know those are up right now before the legislature. We're trying to figure out what they're going to decide regarding capital gains, step up in basis, but I'll give you an example. A typical house that was purchased, and I'll give you the Astoria example. Typical house purchased in Astoria in the 1970s was for about $70,000. That same house is likely 2 or 3 family house could be worth about $1.5 million now, right? If you gift your house to your child, you are giving them your tax basis, which is the price that you purchased it, plus any appreciation minus any depreciation. If it's a multifamily house, chances are you've probably depreciated it through the years to avoid the income tax that hits, right? And so you may be depreciated down to 0 at this point. You give your house to your child, you are going to give them your tax basis of 0. When they sell it for $1.5 million or $2 million or $3 million in the future, they will pay the difference in capital gain between your 0 basis and the price that they sell it at. So they'll pay the capital gain on all of this gain. So it's important that you don't just transfer your house outright to your child. You would put it into a trust, which would still give you the benefits of living in there, of collecting the rental income, of getting the tax decreases for the real estate. And then at your death, the trust says that these are the people who inherit. It basically takes the place of a will for the assets that are in the trust and directs who's going to inherit those assets at that time. And the other beauty of the trust is that it avoids the court process. It avoids what's called probate, which I'm sure many of you have heard. Probate is the process at which a will goes through the court system to be proven as a true will, which right now probate is taking anywhere from 3 to 5 months to get through. I never used to be afraid of probate. I never had an issue with probate wills here for breakfast, lunch, and dinner. We do a lot of estate work here. So probate was never a big deal, even if it took a month, but now it's taking anywhere from 8 weeks to 16 or 20 weeks for a simple probate, just for them to get to the document. So that's why at this point we're starting to recommend that if this is something we are, going to be engaging in Medicaid planning, this is another benefit of a trust that you can engage in. There are going to be a lot of questions about specifically applying for Medicaid, and I'll touch upon some of the income ramifications, but I don't want to get too technical because I think it can get very complicated. We talked about the resources, right? So if somebody transfers their assets to try to protect them from Medicaid, let's say they put them into a trust, the trust will hold the assets. The assets are no longer considered theirs as long as the look back period has passed, right? Say we have a scenario where that same couple who came to me 5 years ago, we put the house in a trust, they kept their $100,000. The husband comes to me and says, Constantina, my wife had a stroke last week. She's going to need long-term care. What do we do, right? If the wife is going to return to the community at home and she's going to get home care, we've passed the look back. We're going to use the power of attorney that we prepared 5 years ago, right? We prepared power of attorney, healthcare proxy, living will, and a trust. We're going to use the power of attorney to move all the assets out of her name and put them into his name. Not her IRAs though. Her IRAs are going to stay intact. They're going to remain in her name. I'm not touching her retirement accounts, her 401ks, her IRAs, her IRA annuity remains in her name. The only assets I'm going to move over to him are bank accounts, checking accounts, life insurance policies, annuities that are non-IRA. All of those assets I'm going to move over to the husband. And I'm going to put in an application for community Medicaid for her. I'm going to show my 2.5-year look back because chances are they may come to me at the time where the 2.5-year look back is in place. And now what I need to do is I need to know what her income is and what his income is. Okay. So let's say she has an income, the wife has an income of $1,904 a month. And his income is another $1,500 a month. When we apply for community Medicaid, we're going to have to show the income and assets of both spouses. Okay. If he has a significant amount of money, we would do what's called a spousal refusal. Otherwise, we would submit the application. If he's under the $130,000 or so, his income is a modest income. We're going to leave him as is. We're just going to show his assets. We're going to show her income and tell Medicaid that she has $1,904 in income. So because she's above that $884 income threshold, what would happen is that we would have to then have two options. Number one is that we transfer that income, we send that income, that extra income, which is actually going to be a straight $1,000 because she has an extra $20 disregard. So Medicaid allows her to keep $904. If she had any other medical expenses, we can use those as well. But let's pretend for numbers' sake, to keep me sane with my numbers, she gets $1,904. She's entitled to have $904 in income a month if she's elderly, right? So that extra $1,000 that she gets every month, she has those two options. Number one is she can pay it to Medicaid as a contribution toward her care. That's option one. I don't like that option. We're going to take option two. Option two is we create something called a pooled income trust. The pooled income trust is set up with a not-for-profit organization that would automatically debit her $1,000 extra from her checking account every month. So her Social Security would feed in, and we'd have the pooled income trust automatically debit that extra $1,000 a month and send it into the not-for-profit organization. That organization is going to take it, put it into their account, and we're then going to use the funds for her expenses. So we'll use it to pay her Con Edison or her light bar or her whatever other expenses she has, her credit card bills, her food, anything, her rent if she needs it, whatever it is that she needs, that's what we're going to spend that $1,000 on every month. But that 1,000 has to leave her account and go into this pooled trust. Again, it's an irrevocable trust, which only deducts the extra income that she's not allowed to have, the spend down, that's the other term for it. So we would automatically debit that $1,000, put it into the pooled income trust, and that pooled income trust will hold her $1,000, and the spouse, the husband, will submit bills to that pooled trust every month to use that $1,000. Now, obviously, there's going to be a fee for that. So they charge, the one that we use charges $20 a month. So he'll be able to use $980 a month. If, let's say, he only uses 500 of that 980, that extra 480 will roll into the next month. So it's really just another bank account just out of the control of the applicant. And that's the point of doing the pooled trust. The pooled trust removes the assets, the income from their control, but Medicaid allows that to happen as long as the applicant is disabled. You can enroll in this pooled trust with the chances are when you're applying for long-term care, you need a disability and you qualify to enroll in that pooled trust. And so that's what that pooled income trust will do. It will protect your spend down so that you don't have to take option A, which would be to give it all to Medicaid. Because who can live on $904 a month in New York, right? It's a very difficult threshold to meet. If you're going to be using, you're going to be giving away the extra 1,000, you're living on 904, people could barely afford rent at that point. So that's why New York State has created this pooled trust and allows this to happen so that we could be able to protect that person's extra income and allow them to stay at home. Now, if let's say the spouse can't return home and they have to go into the facility, we're going to go and do a nursing home application, an institutional application. And with the institutional application, we're going to request that her extra $1,800 gets transferred, or $900 goes to her husband so that he can live in the community with her money. And so Medicaid allows for a certain amount of money to be kept by the spouse who's in the community. Once you reach that threshold, though, any extra money above that, which is hers, would have to get paid to the facility as a contribution toward the care. That all gets very technical, and I don't want to dwell too much on it because it's very fact specific. Doing an application is a lot of work. We literally comb through bank statements, we crisscross, we figure out where one went, where what money came from, where it went, where it was paid out of. There's a lot of back and forth. We need to calculate exact figures when we're doing these applications. We need to know whether or not, their gross income is one number, their net is another number, because Medicaid always goes off of gross. They don't care if you're using money to pay taxes. They want the gross number. So it's important that all the documents are submitted properly. Now, a sign of caution is sometimes clients go to the nursing homes and have the nursing homes do the applications because they're free. I always caution my clients against that, obviously, because the nursing home's preference is to get paid. And if the application isn't done properly, say there are a lot of transfers, or say there is significant amount of money that needs to be protected, or a spouse that needs to be protected, they're not looking out for the spouse. They're not looking out for the applicant. Unfortunately, they have to get paid. They're just trying to do this Medicaid application to get paid. And so we've seen a lot of these go wrong, where the application has been submitted and now the spouse has to give up a lot of money or has to do things very differently from where they would have had they gone to an attorney to do this specific type of work. So that's always a sign of caution. There was a lot that we just talked about in an hour. I want to start taking any questions. I see that some questions have come into the chat, so I'll go through those questions and then we can also open the floor for some Q&A. Jacqueline, is that good? Okay. All right, I'm just going to start with the chat. The income from the two-family house, I think I answered that question. If you have income from a two-family house, do you have to put that income into the trust? The answer is no, you don't have to put income into the trust. I do recommend that a trust account be opened and that the income is paid to the trustee. I don't know where that sound is coming from. And then the net income is given to the grantor. So after the payment of taxes, after the payment of the water, just to comply with the terms of the trust, that's typically best, but it depends on how the trust is worded. But ultimately the net income does come to the grantor as long as that's what the trust allows for. Proceeds of the sale of the house that was, oops, I'm sorry, this is moving. The proceeds from the sale of the house that was in the trust, who owns that money? The trust owns the money. So essentially at the closing table, if the trustee has entered into a contract to sell the property, the trustee is the person who's going to get that check at closing, and they will have to deposit it into the trust account. And so the payee, the person getting the check, is the trust, really. The trust receives the proceeds go into the trust, and the trustee could then invest the money into another residence, or they can put it into stocks, bonds, they can invest it to make income. It depends on how the trustee wants to invest it. To apply for Medicaid, the income from a two-family is considered income. So I think I answered that as well. Medicaid does not necessarily take the income. It depends on what the net income is, whether there's an intent to return home, whether it's a community Medicaid application. So all of that comes into play when deciding how much money would end up having to be paid to Medicaid, and none at all. You can set up the pooled income trust if it's a community Medicaid application. So there are ways around protecting the income from a multifamily house. I'm not sure, Jacqueline, you had mentioned something about, does that work for just one living spouse? If you can clarify what that was.
Can we do verbal questions?
I guess as soon as I get through the chat ones, I'd be happy to do that. Jacqueline, I don't have your full name. So Picciarelli, if you're still there, you had asked a question about, does that work for one spouse? And I'm not sure what you were referring to. Okay, Jacqueline, if you can, the pooled income trust. You can set up a pooled income trust for two spouses as well if they're both Medicaid applicants. You can absolutely do it for two spouses if they're both applying for Medicaid. You wouldn't want to set up a pooled income trust unless someone is absolutely applying for Medicaid. That's the last step that we take when we do the application. Okay, I'm happy to take verbal questions.
Okay, may I?
Yeah, sure.
Okay, my question is around the mechanics of the lien. When let's hypothetically, surviving spouse has a quick event where they need to be in a facility, and you make a Medicaid application. And in other words, there's no cash there, let's say. There's $1 million house though. So who pays the facility, and what are the mechanics of the lien if they, make a Medicaid application?
So you're saying there's one spouse left?
Yeah.
All right, so that one spouse needs nursing home care.
Yep.
Okay, so if one spouse is gone, then you come to me and you say, my surviving parent now needs to go into a nursing home. You
Right.
can apply. I'm going to try to see if you meet any of the exemptions. There are some exemptions, like if there's a child living in that house for 2 years prior to the event. So for the 2 successive years, if you were living in that house with your parent taking care of them, I'd be able to transfer the house to you in certain circumstances to protect it. If there's a disabled child, I may be able to do other things to protect the disabled child. So I'd look for the exemptions first. At the worst case scenario, if there's nothing that I can do to protect that house, your dad would go or your mom would go into the nursing home, and his income, excuse me, the income would have to be paid. His income or her income would be paid to the nursing home as the net amount of monthly income. It's going to be calculated based on what the income is. And then the house would remain where it is. Now it's complicated because if the house can't pay its own expenses, right? Let's say it is a multifamily house. If it can pay its own expenses, the net income will go back to the applicant, and that will count as part of their contribution toward the nursing home. But if not, and let's say it's a house in Nassau and it's not rental, and now dad has gone into the nursing home and you can't afford to upkeep it, you may have to sell it.
Well, what if, plain vanilla example, single family dwelling anywhere, Queens, Nassau, and let's say the kids can afford to pay the taxes, but they want to try to retain the capital gain. You know, they paid $1 for the house, it's not worth the step up.
So
I guess what I'm still trying to get at is, what are the mechanics of how the facility gets paid, and can they, if they're paying the taxes from California, Florida, wherever they are, can the house maintain itself, and at the same time, mom or dad is in the facility and Medicaid is paying with the lien?
Medicaid will cover, there is no lien until they die. Medicaid will cover the cost of their care. They will have to give their income to the facility as well as a contribution toward their care.
So is the lien, like, if there's a after the income, let's say there's a $10,000 deficiency, is it kind of go like that, 10,000 a month times a year? No.
So what's going to happen is Medicaid will cover the cost of their care, and at their death, Medicaid will impose a lien for how much money they spent on their care. So if dad was in the facility for 5 years and Medicaid spent $500,000, Medicaid will impose a lien on the estate to recover back from that house. So if that house is worth $1 million and Medicaid paid out $500,000, there's going to be a $500,000 equity for the family. But if the house is $500,000 and Medicaid spent $500,000, the house is essentially going to be used to pay the lien. Now, at that point, you can try to negotiate with Medicaid. We do that all the time. We try to negotiate a lien down, but it would be after death. It's not something that they can get during life.
Okay, thank you very much.
Whatever care they gave, that's what they want back. So,
Right, and if they don't have enough cash flow, then the facility will say, well, who's paying for the, okay, so part of the
cash
application.
flow doesn't matter, right? So what Medicaid does is they look at your income, they'll look at your Social Security, your pension, whatever it is that you're collecting, and they're going to calculate the amount of income that you can send to them every month.
Part of the application is they know that you own a house, and they will, okay, so that's how they catch it.
And they'll put the lien at the end, correct?
At the end. Okay, that's question answered. Thank you very much.
Okay, no problem. Does anybody have any questions? Okay, I don't know. I don't see anybody else with any other questions. I hope this was helpful. I hope that you were able to understand a lot of it. It's a lot thrown at you in an hour. I could talk about this stuff all day. So if anybody has questions, my colleague has added my contact information into the chat. Feel free to reach out. If you have any questions, I'd be happy to answer. And I'd be happy to speak with you for whatever it is that you need help with.
Thanks very much.
So much, Constantina.
Thanks for attending, everyone. Have a great day and stay safe.
Thank you.
Take care. Bye.
Bye-bye.